The next speaker is Alexandria Corey, followed by Wendy Brennan.
Good morning. Thank you for the opportunity to testify today. My name is Alexandra Corey. I am chair of the New York Advisory Committee to the U.S. Commission on Civil Rights. I previously submitted the committee's report into the BOC's record, but I have a copy here if you'd like it. On Tuesday, as you know, the New York Advisory Committee to the U.S. Commission on Civil Rights released its report calling for the elimination of solitary confinement or punitive segregation of youth, which we broadly defined as under 25, in all jails and prisons in New York State, including those in the city. The report is the product of over 6 months of investigation, including a hearing in committee held in July of this year and a visit to Rikers Island in June. Sorry. The committee has concluded, is that better? The committee has concluded, among other things, that New York's use of solitary confinement against youth constitutes a violation of their civil rights, and that the DOJ should use its enforcement powers to force its immediate elimination. As we know, New York City plans to eliminate punitive segregation for 16 and 17-year-olds at the end of the year, as set forth in paragraphs 1-17 of your proposed rules. We commend that rule, but and the other reforms that Commissioner Pont has discussed, but we do not think it goes far enough. In the first place, it seems to be conditional on this new ESH unit, which we ourselves did not look into, so we do not have a comment on. But I would note that we would, I think, have some due process issues with it, since the type of hearings that are called for, issues that we had with respect to the current hearing process in both the city and the state. But most importantly, it does not address 18 to 24-year-old cohort, which I think Dr. Cohen, you mentioned as well. The committee has determined that youth under 25 in solitary confinement, including Rikers, are subject to dehumanizing conditions, which have been recounted many times by many others and do not need to be repeated here. The committee has found that these solitary conditions have devastating effects on youth, including exacerbating any existing mental health problems, increasing the risk of self-harm and suicide, causing serious deterioration of physical health, and stunting social, emotional, and physical development. I note that Commissioner Pont noted a few minutes ago that those who have mental health issues, and ARP statistics showed 48% at least at Rikers, I think his statistic was 33%, had a disproportionate amount of violence attributed to them. So I would note that I'm not sure why punitive segregation, which would exacerbate that, would actually help with the violence issue. The detrimental effects are so severe in New York's prisons, so obviously indifferent to its effects, which is the test that the Supreme Court has used for criminal and unusual punishment, as to be unquestionably inconsistent with the standards of decency of a mature society. As a result, we believe that this constitutes cruel and unusual punishment under the Eighth Amendment. And since the overwhelming evidence from a medical point of view is that the portion of the brain responsible for impulse control does not fully develop until somebody is in their early 20s, imposing solitary confinement as a response to that lack of judgment seems to be particularly cruel. Moreover, the practice of solitary confinement constitutes impermissible discrimination. Black and Latino youth are disproportionately the victims of solitary confinement discipline, as they are disproportionately represented in New York State, city, and county prison systems. Blacks and Latinos make up 88% of those arrested and 94% of the arrests resulting in incarceration in New York City, and thus they are disproportionately represented in solitary confinement. Given these findings, and the U.S. Department of Justice's mandate to ensure the fair and impartial administration of justice for all, the committee has recommended that DOJ use its statutory authority to commence civil actions to effect changes to the confinement in New York as soon as possible. And obviously, Preet Brar has announced some litigation yesterday as a follow-up, but there are many other steps we wish the DOJ to take. Most importantly, the committee has recommended that, as I said before, that the DOJ use its enforcement powers to require New York City to eliminate the solitary confinement of inmates under 25. The committee has a host of recommendations in its report that it's submitting to the BOC. With respect to alternatives to solitary confinement, and there are many experts who have testified before us and who will testify today who have who are more expert than we are at that issue. However, I would note a few things that we have recommended. As a number of people here have talked about, there needs to be very thoughtful programming associated with any alternative programming associated with any kind of confinement in a special unit or in-cell or whatever. These kids also need to have adequate education while they're confined. They have to have visiting privileges. They have to be treated with a tremendous amount of intervention, as Dr. Bandy Lee testified to us, and who's an expert at Yale in mental health issues. Intervention is an extremely important part of getting these youth to be part of our society, and I will end there. Thank you. Thank you.
Question?
Thank you.
You're very welcome.
The why 25? How do you reach the age?
Well, the experts, and again, the experts in the area suggest that it's in the early 20s when the prefrontal cortex, gets fully developed. So I think that most of the experts who are mental health have suggested that sort of somewhere in the early 20s. I don't think it has to be 24, but it's somewhere in the early 20s.
Thank you.
You mentioned briefly about the due process concerns, and if you were listening right now, DOC has made a commitment to eliminate solitary confinement for under 18 and above. Can you just elaborate on what, having done this investigation and written this report with your recommendations, what your due process concerns are for those who go through the infraction process?
Well, from an administrative law perspective, it seems that the individuals who are entitled to a lawyer as a matter of right in New York City when they appeal their placement in solitary are the hearing officer is somebody who is usually a former corrections officer, as I understand it. There is no right to witnesses or right to cross-examination. And so there are certain protections that I think we would recommend that an individual have a right to, such as outsiders, outside legal counsel, the right to be heard by some administrative, as a comprehensive matter, an administrative judge of some sort who had no particular bias one way or the other. So that's what we were referring to.
Thank you, Ms. Ford.
Thank you.
Wendy Brennan, followed by Dr. Chalice.
I just wanted to say that as we get into the non-New York City participants in this hearing, it is a
And actually, in terms of all speakers, if they could announce their affiliation, I think that would be hugely helpful. Ms. Brennan?
Good morning. I'm Wendy Brennan. I'm the Executive Director of NAMI New York City Metro. And I'm here today to state the organization's unequivocal opposition to the use of solitary confinement for people with mental illness and to oppose the proposed rule change that would authorize the establishment of enhanced supervision housing units, which in our opinion is de facto solitary confinement for inmates in the custody of the New York City Department of Corrections. It is well documented that solitary confinement can have a highly negative and long-lasting psychological effect on individuals with mental illness. Solitary confinement may cause people with mental illness to experiencing worsening symptoms, which decrease prospects for recovery and successful community reentry and reintegration. Not only can solitary confinement cause and exacerbate symptoms of mental illness for those living with mental illness, but can create long-term psychological damages to individuals who do not live with a behavioral health issue. The United Nations and European Court of Human Rights determined that prolonged solitary confinement constitutes torture of all people. The de Blasio administration is committed to improving outcomes for justice-involved individuals with behavioral health issues. The action plan outlined on December 2nd, the Mayor's Task Force on Behavioral Health and Criminal Justice, contains many effective initiatives. In light of the task force report, we were disheartened to learn that the administration had no plans to reduce the number of solitary units. In addition to continued use of solitary confinement, the Board of Corrections is also seeking to institute a new form of punitive segregation, ESH units. Section 116 of the proposed ESH rule outlines the criteria for placement. Criteria 5 states that someone can be placed in an ESH unit if he or she otherwise presents a significant threat to safety and security of the facility if housed in the general population. DOC personnel, like the public at large, have discriminatory beliefs about people with mental illness. These beliefs can lead people to assume without cause that individuals with mental illness are violent and dangerous. Given the catch-all element of this rule, coupled with the well-documented discrimination and violence against people with mental illness at Rikers, we believe that people with mental illness will be overly represented in ESH units, just as they currently are in solitary confinement. The rates of violence escalating at Rikers during a time of increased use of solitary confinement is counterintuitive to believing that adding a new form of punitive segregation will make Rikers Island a safer jail for personnel and those currently incarcerated. We're all working to identify effective means to ensure the safety of all people at Rikers, and yet the proposed solution sounds like more of the same, a potential means to perpetuate a culture of violence and further reduce safety. We commend the correction officers and their ability to do the work that they do in light of incredibly limited options to establish safety and security. We ask the Department of Corrections and the Board of Corrections to consider alternative options outside of additional punitive segregation units to achieve our common goal of reducing violence.
Thank you, Ms. Brennan.
Thank you.
Thank you.
As you may have heard me say, the correction officers are asking for additional training with respect to working with the population, especially in that so many of them suffer from mental illness. Do you have any recommendations as to what that training should look like in light of your position?
It is my understanding, but perhaps I'm wrong, when I read in the task force report that the administration released that they would have crisis intervention training for Department of Corrections officers. It was also my understanding that that's something the Department of Corrections was interested in. This is an evidence-based practice. I know that it was used in Maine. I know it wasn't used in the state of Indiana. Really gives people information about mental illness. It helps to give people tools they need to de-escalate violent situations, and it's been known to be very effective and to improve safety not only for corrections officers but for people who are incarcerated as well.
So assuming the training is an 8-hour training and not the 40-hour crisis intervention training, do you think the 8 hours would be sufficient?
I am not an expert in this, but doing the math, I think that much more needs to be done. I mean, I think that everybody, all the stakeholders would agree that they're cultural issues, and that, for, as I said in my testimony, for society at large and people who work at Rikers are no different. There are cultural issues and basic discrimination issues that I think do need time to be changed. I don't think an 8-hour training would be sufficient. I do know from having spoken to people who've implemented this in Indiana that it has been very successful in their prison population throughout the state.
Yeah, Chief, I want to thank you for your testimony. I think you've outlined something that's very important here, which is that the stigmatization of mental illness and the attempt to link it to violence is very dangerous. Although the city did put forward a behavioral task force around criminal justice, some of that ends up being blaming. I believe, and I'm particularly concerned on Rikers Island, that we have to recognize that the conditions of incarceration enhance violence in everyone, and particularly in the mentally ill. So the solution is not programs as much as it is not incarcerating people with mental illness and getting them out as quickly as possible. Many of these people are there for very short periods for long periods of time on very low bails. And it is something the city did not effectively address in the mental health program. And I'm glad that you've been here to speak on their behalf. Thank you.
Thank you.
Thank you. Our next speaker is Dr. Chellis, followed by Professor Alan Yurachevsky.
Hi. My name is Frances Vitellis, and I'm a clinical psychologist licensed here in New York State. And for many years now, I've been a member of the Asylum Network of Physicians for Human Rights, providing psychological evaluations of torture survivors. So I think that is relevant since solitary confinement has been defined as torture. you've already discussed many of the implications of solitary confinement, and I would like to support some of the remarks that have been made regarding the way in which it tends to increase despair, depression, anger, aggression, rage, and loss of impulse control, and that this is not just an increase in the psychological symptoms and the behaviors themselves, but there also is evidence that the parts of the brain that are most affected by isolation are those parts that deal with regulation of aggression and memory and clear thinking. So that, again, I would reinforce the notion that we have to eliminate solitary confinement, and especially eliminate it for those with severe mental illness, and eliminate it, not just severe, I think mental illness, because even moderate mental illness, since we know that for those people, there's a strong, even though we know that solitary confinement can have a deteriorating effect for people who don't have psychological problems prior to admission, it certainly intensifies the problems of the people who do have pre-existing psychological problems. But I would like to say that in addition to eliminating solitary confinement, you also have to eliminate the culture of punishment, which is a determining factor here. Instead of the guards constantly reacting in negative ways with punishment, opposition, force, and repression, different modes of interaction with the people they are caring for must be developed and taught. And this goes then to the question of what kind of training might be required. We know, for example, that behavioral change can more readily be accomplished by recognizing and rewarding positive behaviors. Instead of an atmosphere that increases stress, tension, and hostility, a more peaceful environment must be fostered. Unfortunately, the new proposal does little to address the environment of punishment and hostility at the prisons. The recent study by the U.S. Department of Justice made it clear that violence at Rikers is not only perpetuated by the people incarcerated there, but that it is also something that is perpetrated by a staff that is violent and brutal. Yet the new proposal doesn't address that at all. The only focus is on a new way to punish the people who are being held as prisoners. And so I would raise the question of what kind of message do you think that's sending? There is such an inherent injustice that is built into that how do you think it will affect the mind and behavior of the people that you're trying to control? It seems to me that there are, and I would say there are other injustices that are built into this new system. One of them I see in the question of the definition of who will be subjected to the new units. It's overly broad and general, with lots of opportunity for arbitrary and discriminatory enforcement. One of the, since my time is limited, I think given this pattern of injustice that is written into the proposals, and by the way, people talk today about reestablishing the right for contact visits, but that's not written into the proposals. The only thing you have written in there are the restrictions. The more positive aspects of what is being talked about are not even stated anywhere. Similarly, the response before that someone said, well, we've always had the right not to put the mentally ill in solitary confinement. If they had that right, why was it constantly done? And how do we know it's going to be any different with these new requirements? I don't see that. So what we need to foster is a situation where there is a need to heal. And when I talk to torture survivors, what I often ask about is what helped you to survive? And the things that are mentioned are community, family, and religion.
and you're attempting to restrict all of those. That makes no sense. So I ask you not to approve this policy as written.
Thank you, Dr. Ellis. Chair, there's a question, Doctor?
Oh. Sorry.
In your professional judgment, is there any possibility of reversing the adverse effects of solitary confinement? And if so, what does that process look like?
Well, I think I hinted at to some extent in the end that some of the things that are needed to heal involve having a safe environment, having a support system, having contact with family, and possibly religious groups and community. I think therapy can be helpful as well. But in my experience, sadly, when the people have experienced torture or oppression over long periods of time, what happens is, even if there's improvement, I very often find that under new stresses, the symptoms can be reactivated. And so I think there tends to be a fairly permanent component to that. And that's something we should be avoiding as much as possible. I recently served as an expert witness on a lawsuit against one of the detention facilities, and I examined the people when the lawsuit was first filed, and then 5 years later, because we hadn't yet gotten to court. And there was a lot of healing, but there were still serious problems that some of those people were encountering.
Thank you, Dr. Chubb. Our next speaker is Professor Ellen Yaroshevsky, followed by Sidney Schwartzman. Professor.
Good morning, Commissioners. I'm the director of the Youth Justice Clinic at the Cardozo School of Law here in New York City. In the fall of 2013, Kathy Potler, the former executive director of the Board of Correction, requested that our clinic research and prepare a report for this board on solitary confinement practices for 16 to 18-year-olds in jurisdictions around the country. Our clinic soon learned that because New York is virtually unique in treating 16 to 18-year-olds as adults in our criminal justice system, there were few, if any, jurisdictions that had such a draconian approach to youth confined in its jails. As you no doubt know, and we've heard this morning from various studies, solitary confinement for 16 to 18-year-olds violates international norms, is extremely damaging to the emotional, physical, and mental development of youth, creates conditions for a culture of violence, increases the likelihood of reoffense, is costly, and is terrible policy. Our clinic surveyed correctional systems in a number of states and learned that effective policies required not only an elimination of solitary confinement for youth, but a more fundamental shift from a punitive correctional model to a cost-saving, effective therapeutic one. Such a therapeutic approach has been successfully adopted by various jurisdictions, including Maine, Connecticut, Mississippi, and Rhode Island. It's been adopted as well in New York by OCFS that fosters a positive rehabilitative environment offering a range of mental health, educational, vocational, and life skill supports and services. The institutional concern about safety has been demonstrated to be more effectively addressed by such positive behavioral intervention. Our clinic prepared a report and presented it to Kathy Potler for this board's consideration. I have copies of it with me in case you don't have it. We continued to work with Ms. Potler until her untimely death in September on the anticipated rulemaking process to improve conditions at Rikers. Our expectation, especially after the appointment of Commissioner Pont, was that there would be a necessary move away from ineffectual, dangerous, and costly punitive correctional Rikers model to a rulemaking that advanced a therapeutic approach, including additional programming for mental health, education, recreation, a range of positive behavioral intervention, and training for corrections officers. And we specifically began to work on a report on CIT training, crisis intervention training. Even though there's been some significant movement that Commissioner Pont pointed to, the announcement that the Department of Correction will no longer use solitary confinement for 16 to 17-year-olds, forms of punitive segregation remain in effect for 18-year-olds and certainly for all youth under 25. The new unit that we've heard about, the Adolescent Transition Repair Unit, adopts some programs, and it will, but certainly, as we've heard, it doesn't meet the minimum 14-hour lockout that this board has as its standards. Youth are locked out for 20 hours a day, better than 23 hours, which we used to have, but it does not comport with modern effective practices. Minor adjustments within this fundamentally flawed model are just that. They're minor, they'll be damaging, ineffectual, and costly. The current proposal for the ESHU that affects youth 18 and over is yet another flawed proposal. It may not be called punitive segregation or confinement, but without sufficient programming, lockout time, and specifically training for guards, it will have a similar effect upon the mental, physical, and emotional development of youth, and it's likely to increase the culture of violence. The ESU, especially for 18-year-olds, flies in the face of every set of national standards governing age and developmentally appropriate practices to manage youth in rehabilitative or correctional settings. National standards strictly limit all forms of isolation. The JDAI, the Juvenile Detention Alternatives Initiative, creates a comprehensive set of standards strictly limiting the use of isolation for youth up to age 18. The standards have been adopted around the country in more than 200 jurisdictions and 39 states. Instead of positive intervention, this ESU proposal seeks to restrict services, education, recreation time, religious services, library services, family contact, all of which are likely to increase anger, frustration, acting out, and consequently altercations and violence. It's wrong-headed and it's dangerous. It's contrary to best practices and current research on effective strategies. Instead, effective programming, notably for mental health and education and recreation, is essential. We've already religious programming, library time, and recreation should be increased. Family contact should be encouraged, not decreased. And there are effective positive behavioral intervention programs that have been adopted around the country for gang-related violence. I'm told that I have to stop. Let me just add that institutional safety is not enhanced by such a unit. There are studies of correctional systems around the country, Illinois, Arizona, and Minnesota, and they have found that by reducing punitive segregation isn't as risky as correctional officials may fear. Some states have begun to rethink their punitive segregation policies and limit its use to extreme circumstances. And these recent advances in other jurisdictions highlight the best practices. And with regard to mentally ill and adolescent inmates, the Vera Institute is now working with a number of states, including Pennsylvania, Illinois, Maryland, New Mexico, and Washington State, on a database program and on a program-based segregation reduction project. I commend that to you. I also commend to you a report that was prepared for this board by Professor Elizabeth Panuccio called Best and Promising Practices in Punitive Segregation, all of which indicate that one can't effectively establish a unit like this unless you have sufficient programming, and specifically, as Commissioner Cohn and others have pointed out, effective training for guards.
Thank you publicly for the support of you and for those law students, and also for your support of Kathy Potler. Questions?
Thank you.
Thank you. Our next speaker is Sidney Schwartzbaum, followed by Dr. Daniel Selling. I might add, we have 104 speakers signed up.
Good morning. Good morning, Chairman Campbell, members of the board. My name is Sidney Schwartzbaum. I'm the president of the Assistant Deputy Wardens Association. I represent men and women in the titles of Warden Level 1 and Warden Level 2. I'm here today to support Commissioner Pond's initiatives to institute enhanced supervision housing to help curtail the large increase of violence which plagues our jails. This new housing is necessary to address the ever-increasing violence undertaken by our most violent SRG inmates. SRG is an acronym for Security Risk Group. On an ongoing basis, dangerous inmates who leave punitive segregation are released into general population only to continue their reign of terror. The Department of Correction is at a crossways of attempting to reduce punitive segregation while curtailing violence. Enhanced supervision housing is a viable tool to closely monitor the small percentage of inmates who commit most of our violence. I have handed out some pictures to members in the audience to show you some of the inmates who have been viciously attacked by gang members as a show of power and influence. These inmates who perpetrate this violence are the judge, jury, and executioner. So what do we do with a prisoner who leaves punitive segregation after 30 days who commits these type of acts? ESH is needed as an alternative controlled area with enhanced supervision to minimize the influence and mobility of our most problematic population. This initiative will enhance security and provide a safe environment for staff and inmates alike. I urge the board to approve this new housing. A couple of points I want to make. I've heard the term solitary confinement over and over again. Solitary confinement conjures up images to me of Shawshank Redemption, James Cagney movies. I ask the board, and you're all expert on it, maybe I'm wrong, is there a terminology in the Board of Correction minimum standards that says solitary confinement? Is there any paragraph that delineates solitary confinement? Isn't it punitive segregation? I know everybody wants to make it interact, but is there, Mr. Cohn?
I don't know if there's anything in the board, but there certainly is a condition of solitary confinement, which is...
I understand that, but within our minimum standards, is there terminology?
The terminology says that you
isn't it called punitive segregation? Isn't that a true fact?
It's called punitive segregation.
So, okay. There are signs in the audience that says ESH is torture. That is a complete fallacy. ESH is not torture. And somebody has a sign that ESH inmates deserve law library. And all inmates deserve law library. Except 2 weeks ago, there was an incident in the law library in the George R. Verno Center, which you can observe an orchestrated hit on an inmate where 3-4 inmates in concert set this inmate up, and it was on videotape. And if somehow, some way, I wish the people who are against ESH would see this, and you would see a group of 3 or 4 inmates distracting the officers, blocking their way, and then slicing somebody's face open. If I may, I would like to give the board some pictures and let them look at. Some of
We'll just keep it brief. You can just call them and we will. Thank you.
My time is not up. I think everybody in this audience is really after the same goal, and that's a safe environment for inmates and staff alike. Safety is paramount. And there are many civil rights advocates here. I'll end this with this. The greatest civil right is the right to be safe. And a lot has been said about inmates who are mentally ill. A lot of those inmates, I would urge the board to stop, to make some initiatives. They don't belong in jail. And correction officers are not trained to deal with some of those inmates. So I would urge you to come up with some initiatives to place these inmates where they belong in mental hospitals.
Thank you. Okay, our next speaker is Dr. Daniel Selling, followed by Elena Mendocino.
Good morning, Board. It's a pleasure to speak before you today. My name is Dr. Daniel Selling. I'm a psychologist, and until 6 months ago, I served as Executive Director. Start again. My name is Dr. Daniel Selling. I'm a psychologist, and until 6 months ago, I served as the Executive Director of Mental Health for the New York City jail system. I spent every working day working on Rikers Island, in and out of every jail, and have forged strong relationships with my DOC counterparts. I spent the last 15 years of my life working in jails as a psychologist, shaping mental health policy in various jail systems. I possess a robust context to which understand the current problem of violence, segregation, mental health care, and aftercare in this jail system. I've been part of the highest level meetings for the past 8 years with both commissioners of corrections and the commissioners of health. My team designed and implemented many of the existing programs in this system, many of which I'm proud to say are operating today. But unfortunately, the majority of the programs that we jointly created and implemented have been totally perverted by the Department of Corrections. If you allow the DOC to pass this new Enhanced Supervision Housing, or ESH, it too will become quickly a newly branded version of punitive segregation. There are many in the system. They all have a sexy acronym, all were intended to solve a specific problem, and all eventually became an oppressive and abusive system of solitary confinement. Like members of this board, I chose this path to ensure that the jail system is operating optimally and not conferring harm to our patient population. The board was originally tasked and agreed to the challenge of rulemaking for punitive segregation. On September 9, 2013, the board unanimously voted to initiate rulemaking regarding the use of solitary confinement in the New York City jails. As of today, the board has failed to deliver on this obligation, while hundreds of inmates remain in prolonged solitary confinement. Here we are today, no longer talking about proposed standards, but rather proposing a new form of confinement. I'm asking you to vote against the ESH because, as you will see, every joint program on solitary confinement has essentially failed. The Department of Corrections has a solid and lengthy history of promising a lot, but when it comes to delivering, it fails. I can honestly state that over the past 8 years of my career, I've spent more than 60% of my time with wardens, deputy commissioners, commissioners, and chiefs, pleading with them to support the fidelity of the programs that we jointly created. This is the exact reason the Attorney General's office has decided to intervene. In order to foreshadow why the prospective failing of the ESH will occur, I offer a few examples. These are all examples of different approaches to punitive segregation that the system has implemented. The intensive treatment unit was designed to provide treatment to a challenging subset in the population that were engaging in self-injurious behavior and presented with extreme impulsivity. They were a major management problem for DOC. Both the DOC and the DOH jointly created this program, and within a few years, it started its infamous demise because of pressures from the union to stop coddling dangerous inmates. Another program that failed has been MAUI, an acronym for the Mental Health Assessment Unit for Infracted Inmates. This was created to house inmates with serious mental illness that were serving punitive segregation time. Both departments agreed to open a 50-bed unit, which in no time ballooned to 200 beds. Rather quickly, this turned into a violent and volatile housing unit, and based on large amounts of data, we know that the inmates in these housing units, only 7% of the inmate population goes through punitive segregation, and that 7% comprises more than 60% of all acts of self-harm in the system. When Maui closed, it gave birth to the restrictive housing units. These were designed by myself and other members of the mental health and DOC team. They were designed to create incentives and a program, just as the department has been illustrating for ESH. The incentives are not adhered to. The inmates are not afforded the amount of lockout time that they are supposed to be getting, and this is the same thing that will happen with ESH. The Department of Corrections continues to resort to the easiest jail management agenda by continuing to proliferate segregation, while the national trend is to reduce the platform. The department is addicted to this response and has been prior to my arrival 8 years ago, and will grow increasingly addicted if there is not an intervention. It is the BOC's directive to step in and intervene. This is the reason the board created the rules in order to stop this abuse. The ESH is a flawed plan for the following reasons. First off, it is increasing the footprint of solitary confinement by 250 beds and not taking beds offline. The policy is too obtuse, casts too wide of a net, and essentially houses any alleged violent inmate with very limited due process. More importantly, the unit lacks a proposed clinical programming. It is not in any of the policy and procedures While it may be aspirational, it has to be in policy and procedure, and there has to be clear training in order for that to work. There are enough solitary confinement beds in the system. The last thing Rikers Island needs is another restrictive unit that will expose more individuals detained to increased abuse.
Thank you, Dr. Sell.
One more paragraph. I hope I'm certainly articulating a trend that should cause all board members voting today to carefully ask yourself how the DOC can adequately pull off this unit when they have failed miserably with every other prior attempt. I also ask each and every one of you to ask yourselves how you arrived at this day. Only months ago, you were on the precipice of creating rules to govern this abusive practice, and today you are voting to increase it. I have seen these human atrocities firsthand, and can assure you that this program will not address this intended mission to reduce violence. To the contrary, it will increase violence.
I appreciate you having been there on the inside and being able to offer perspective that others cannot. Is your concern primarily one of implementation, aside from, well, considering that you spoke to concerns about too wide of a net being cast and no clinical program? Is this largely an implementation and monitoring issue for you?
Absolutely. The programs that I mentioned earlier are all attempts to address the issue of solitary confinement, and were all attempts to create a more progressive model. The implementation failed. There would be trainings with hundreds of officers to show face. And when the program opened, maybe 2 to 3% of those officers would ever show up on these units. The programs failed because there were never steady officers on these units. There weren't enough escort officers in order to get the inmates out of their cell and have lockout time. As soon as an inmate on one of these units acts up, which is invariable, you're housing a violent population in these units, the whole unit gets shut down. So as far as lockout, the whole unit gets locked in for the entire day. And this is what's happened in all of these units. So training is essential. It has to be mandated in the policy and procedure, and a program has to be implemented. And none of that has been part of this policy and procedure.
Brian?
Yeah, it's so nice to see you again.
Thank you. Nice to see you.
I enjoyed working with you when I was appointed to the board. We had many meetings regarding the reduction of the use of punitive segregation, and I know you left before the ESHE plan came out. So I would like to just ask you, in light of those conversations, in conversations with health and mental hygiene and senior staff and commissioners there, what are the recommended exclusions you would have to us for purposes of punitive seg, because we are looking at exclusions for punitive seg, and also exclusions for this ESHU, considering an inmate's mental health, mental illness, developmental disabilities, physical illness, and even age based on the neurobiology.
So I'd say that anyone with an Access 1 mental health diagnosis should be excluded from one of these units. The policy sets forth that said that while inmates that are housed on mental observation units would be excluded, that people that do have mental health illness will not be excluded just by virtue of the mental illness. So I'd say anyone with a mental health illness, anyone under 25 should be excluded from one of these units. There should be clear sanctions on how many days somebody could be in this unit. I would recommend 15 days, 30 days maximum. That was the whole purpose of the intended rulemaking, was to set forth rules. While the commissioners have said that, of course, we would like somebody to come out of this unit as soon as they're capable, the system doesn't have the ability to recognize that, or the due process and/or meetings to effectuate that. So people with mental health issues, people with histories of trauma should be excluded. Certainly people with histories of psychiatric hospitalizations should be excluded. Hope I'm answering the question.
In the event they are not excluded for whatever reason, there are treatment programs or programming you would recommend would be in place in the ESH and punitive setting?
Sure. I would recommend there should be clinical programming, just like the CAPS program. That is a mental health intensive treatment unit. The staff, the mental health staff, and support staff ratio to inmates is higher than anywhere else, that they're incentive-based programs. that ensure that the inmates are able to move through this system as swiftly as possible, that there are clearly behavioral programs, cognitive behavioral programs to help the subset that is a violent subset of the population to address their issues of their violence, to understand how to have impulse control in this environment, and to be able to have a reward system in order to incentivize their behavior. We've created these programs throughout the system where there's incentive-based treatment, and in days to weeks, the incentives are lost. They're used against the inmates. They're not used to encourage inmate participation. They're taken away. There aren't systems to properly and adequately ensure that the incentive programs are adhered to, and most specifically with lockout time. If lockout is what distinguishes somebody from punitive segregation from the regular population, you have to have a system to ensure that inmates will actually be locked out for the set forth amount of time. And if you look at the RHU as an example of this, what was told to us in countless meetings was that we don't have enough handcuffs. We can't get the inmates out of their cell. This is a jail. You don't have enough handcuffs? How's that possible? That there aren't enough escort officers to take the inmates out of their cell and get them into group. To say that, I think in the proposal it says that 25 inmates could be out at a time. I've never seen that possible in a unit like this. They're coming out, they're going through metal detectors, they're cuffed. There isn't a procedure to allow this to work effectively.
I just have one follow-up question. I don't know if you were here when the commissioner from Connecticut, Scott Temple, spoke to us and offered some testimony, including that in his experience, these types of units, ESHU in particular, will only work if there is a team approach between all those staff that are working there, the clinical staff, health staff, correction staff. What has been in your experience as to whether Rikers was successful in having an integrated team approach in any of the specialty units?
Sure. So I had the great privilege of starting my career at the San Francisco County Jail, which is the model for a team approach. It's a model where the sheriff's department and the health staff are a team, they're allies, they have the same mission. The health staff are seen as experts within their domain. Here there is the facade of a team approach at the very high level, but when it comes down to implementation, there is not a team approach. That is not to say that there are many officers that have the best intentions, and there are standouts that you see on every one of these units, but they're not offered the support to make one of these programs work. The support has to come from a much higher level, and they have to be actively involved throughout the process in order to create that team. This department was supposed to create an entire mental health team of officers, a cadre that would be a subset of mentally health specific trained officers that would run these units. That never happened. I would strongly urge the Department of Corrections to create such a unit and to have a buy-in at that level, and that those officers should be the ones running any of these programs and would make it much more effective. I also need to say, and to further what Board Member Cohen said, it's really conspicuous that no members of the Department of Health are in this auditorium. It's shocking to me. And it's not an accident. The Department of Health, I can't imagine, stands behind this policy and procedure. I know that they were asked not to be here, not to offer testimony, and every one of you should ask yourselves, why is that? It's not because they support this.
Thank you, Dr. Sallin. As I stated at the outset, I really appreciate everyone being very respectful, but I'd also ask everyone to hold a pause. And also in terms of speakers, it's really important that everyone stick to the time limit because we have many speakers and we want to ensure that everyone is being heard. Thank you so much. Our next speaker is Elena Langostinian, followed by Jennifer Parrish. And then if you could just introduce yourself and what's your affiliation.
Thank you for the opportunity to speak today. My name is Elena Langostina. I'm a staff attorney at Disability Rights New York. Disability Rights New York is New York State New York State's designated protection and advocacy system for people with disabilities. That means that we have federal and state authority to monitor the conditions in the jails and prisons and any facility where individuals with disabilities receive services. Part of our work includes accessing the facilities ourselves to monitor the conditions and to monitor the development of policies like the enhanced supervision policy that is being presented today and discussed today. We are greatly concerned that the proposed rule for enhanced supervision housing will lead to the abuse and neglect of people with disabilities. DOC is trying to move forward with a plan to isolate 250 people in an isolation unit with no concrete plan for how to ensure that people with disabilities receive essential services and receive them in the least restrictive environment, most integrated setting possible. Everything we know about the physical plant and the intended purpose and design of this program leads us to conclude that ESH is punitive segregation by another name. The proposed rule contains no exclusion for individuals with disabilities and no process for diverting people to a less restrictive setting due to a need for a higher standard of care. This means that people with significant disabilities, whether mental illness, developmental disabilities, traumatic brain injury, or physical disabilities, will be placed in ESH. So yesterday, a revised draft directive for the ESH was circulated to a small group of advocates, which seemed to include or reflect a policy decision to exclude people with serious mental illness from ESH. But as we know, that's just a policy decision. It's not reflected anywhere in the proposed rule. So this draft directive doesn't resolve any of our concerns as an organization about how individuals with disabilities will be excluded from ESH. We are also greatly concerned about the impact that the proposed rule will have on the due process rights of individuals with disabilities. DOC plans to use past disciplinary incidents to determine whether to place someone in ESH. Any decision with respect to housing placement should involve appropriate consideration of whether a disciplinary incident, including past disciplinary incidents, is related to a manifestation of a disability or an unmet need for disability-related services. The proposed rule provides no procedure for engaging in that kind of review. The draft directive, again, reflects a policy decision to provide a hearing facilitator to individuals who are illiterate. But the Americans with Disabilities Act requires accommodations for anyone with a disability who has a need for an accommodation at every stage of the process, whether it's an administrative process, an adjudicatory process, or a disciplinary process. And so the fact that the policy is just providing a hearing facilitator for someone who's illiterate is inconsistent with the ADA. Finally, with respect to mental health services, we are concerned that there's no real plan for how to deliver mental health services in ESH and to make those services meaningful. Crucial pieces of information about mental health services have been entirely absent from the discussion. I mean, except for today, there's been some discussion about programming, but there's been nothing reflected in papers or prior conversations. And our concerns about mental health services were magnified when we conducted a monitoring tour on Monday, just a couple days ago. We toured OBCC 1 West, which is one of the locations where GOC plans to locate the ESH. And we also toured 5 North, which is a restricted housing unit. So just to put our concerns in perspective, I want to share some of our observations about these 2 units. 1 West is, it's not operating yet, but it's clearly designed for isolation. The doors to the cells are solid. There's a small food slot, which is, and I'm short, but it's basically at this height. So you can imagine that conversations are going to be kneeling on the ground with individuals on the outside. there's no day room in the unit, and there appears to be no space for a clinical private interview. We were informed that there's no group activity planned for that unit, which is inconsistent with what was presented today. But again, we're getting mixed messages about that. And to date, as I said, there's been no discussion about what the type of group programming would be. It seems that it's still in development.
The unit that you went to that you just described, where it was a solid door, no day room, no space for group activity, were you informed that that was a unit that was being designed for the ESHU?
Well, it's a unit that was listed in the prior correspondence with the DOC to the board.
As an
1 West,
ESHU.
3 West, and 5 West at OBCC.
And with respect to the other units that you went, in your observations of those, the RHU and anything in RNDC?
Sure. So at OBCC, we toured 5 North, which was recently opened as an RHU, and we decided to tour that unit when we found out that throughout the day fires had been set in the cells at 5 North. When we arrived there was an overwhelming stench of smoke, and it was clear that fires had been burning all day long. These fires were set, and we were told that they were set in response to neglect by the corrections staff, and the fires interrupted mental health services for the day, and we were told that for the last several weeks since this unit has been opened, this has been a common occurrence, that fires are set and mental health services are not provided. So the question, I think, for the board is how, given that this is a unit that is supposed to provide some kind of treatment, it's clear, I mean, the purpose of this unit is to provide some kind of intervention for people with mental illness. How is the ESH going to be any different from the RHU, which we all know, and I think the department agrees is a failed model?
Bobby? Yes, just a question. You mentioned the food slots. Do you think that, in my experience in units like this on Rikers Island, mental health services are often delivered through those food slots because, as was mentioned, there's inadequate officer staff to escort people to clinical staff, should it even exist. Do you think that's an adequate way to provide mental health services? And what do you think about the decision of mental health staff to agree to provide mental health services while kneeling?
Well, I mean, I don't know, because there's been no information about how mental health services are going to be provided. I don't know what they're going to do. I think that's something that should be provided to the public so that we can evaluate whether that's an adequate way to provide services. But I think the conclusion that we're left with, given that there's no other opening in the door, is that you're going to be speaking through that slot or through the crack in the door, which is clearly insufficient way to deliver mental health services.
Keep it as my understanding.